Hi, my name is Eric Lewis, and I'm here to tell you about the Pro Se Prisoner Early Mediation Program. The program was developed to help you try to settle your case using mediation. Maybe your lawsuit is about unjust prison conditions, inadequate health care, or something else you believe to be unjust. Regardless of the circumstances, the program will give you a chance to have your voice heard. I can personally say I'm aware of the issues faced within the prison environment because I spent 5 years in the Michigan Department of Corrections myself. At this point, you filed your lawsuit and you're wondering why you never had a chance to discuss your issues with the judge or the people you are suing. Decisions made by the judge come to you through the mail, and it's the only correspondence you receive. Through the Pro Se Prisoner Early Mediation Program, you get to be an active participant in reaching a possible resolution of your case and to resolve issues in a less formal manner. You get to express your concerns informally to the people you are suing. Discussions are led by a neutral party who won't take sides or make decisions about your case. Now, how do you get involved in the program? The next part of this video will provide those details. I'll be sharing some helpful tips to help you prepare for mediation. Just remember, be open, be mindful, so you can take full advantage of this opportunity to let your voice be heard. I'm sitting here with U.S. District Court Judge Victoria Roberts to explain the Pro Se Prisoner Early Mediation Program. Hi, Judge Roberts.
Hi, Eric.
Can you tell me why this program was created?
The program was created to increase access to the courts for pro se prisoners who file civil rights cases under a statute we call 1983. And this program is for prisoners who are not represented by lawyers. And the point of the program is to try to resolve these cases sooner rather than later through the mediation process.
So how does a case get into the mediation process?
All of these prisoners' civil rights cases that are filed are screened by attorneys on staff at the court, and if any part of that case survives that screening, the case will be put into mediation, and the judge will enter an order that stays the case until the mediation process can be completed.
Now I understand there's a filing fee associated. Is the prisoner still responsible for paying that filing fee even in the mediation process?
There is a filing fee associated with the filing of the case under the law that allows prisoners to file these lawsuits, and that still has to be paid. That will never be waived. But there are no fees or costs associated with the mediation process.
So why would a prisoner want to go through the mediation process versus trial?
So mediation could result in the case being resolved sooner. Also, if the case goes into mediation, the prisoner will not have to be responding to motions or trying to get information from the state. The prisoner will have an active voice in the mediation process. The prisoner will be able to actively participate in the resolution of the matter that caused him or her to file the lawsuit in the first place. And then if the case settles through mediation, the settlement could come sooner than it would come if the prisoner went through a trial.
So what if a prisoner does not want to participate in the mediation program and wants to pursue trial?
If the prisoner doesn't want to do mediation, he or she could file a motion with the mediation referral judge. The state could file a motion also. And if the judge grants that motion, the case will be taken out of mediation and it will just go through the normal process of litigation.
And if a case is settled, how does the pro se litigant get their settlement?
The mediation referral judge is going to place the settlement on the record that same day. And that settlement is going to be binding on all of the parties, and the court will dismiss the case. Then the Assistant Attorney General is going to prepare an agreement that has all of the settlement terms in it. All of the parties will sign and date that agreement, and everybody will have a copy for their records. And then if at some point in the future the settlement is not abided by, the judge could enforce that settlement.
And what about situations where a settlement is not reached?
If a settlement isn't reached, then the mediation referral judge will go on the record and place on the record that no settlement was achieved. She will enter an order that requires the complaint to be filed on all of the defendants. The order staying the case will be lifted, and then the case will just go on the normal track towards a trial.
Okay, so how does one prepare for the mediation process?
The pro se litigant is going to get an order from the court that schedules the mediation, and attached to that order is going to be a mediation conference protocol. That protocol is going to explain the process, it will explain the requirements, it will explain to the prisoner how to prepare the written statement for mediation. It will have information in it about the mediator, about the date and time for the mediation. It will attach frequently asked questions and the answers, and it will have other tips for preparing for mediation.
So what about the mediators? Who are they? How are they selected? Are they compensated? Can you answer those questions for me?
Sure. The mediators are all lawyers who are licensed by the state of Michigan to practice law. They are all volunteers for this program. Nobody is getting compensated for their services. All of the lawyers have gone through training, and all of the lawyers have visited a prison facility, so they know the environment in which prisoners are living.
Nice. Well, thank you for the information, Judge Robert. I think that's good to know.
Thank you, Eric.
I think this is a good time for us to learn about the mediator assisting with the program.
Hi, Eric. How are you?
Pretty good. How you doing, Mr. Monicati?
I am doing fine. Please call me Paul.
Paul it is. So, Paul, what is your role in the program?
Well, I'm an attorney and I'm also an experienced mediator. I not only mediate cases, but I also oversee training provided to all our volunteer mediators assisting in the program.
So for those of us who don't know, what exactly is mediation?
Simply put, mediation is a negotiation between parties in a lawsuit where, with the help of a mediator, they work together to find solutions to problems by mutual agreement.
So how can a mediator help two parties settle a case?
Well, there's several things that a mediator can do. A mediator encourages open and honest communication between the parties. They help focus on the real issues in the case. They identify shared interests and goals and concerns. They confidentially discuss with each party privately their strengths, their weaknesses, risks, other factors that affect the outcome of the case if it goes to trial. They can challenge the parties by asking tough questions and raising tough issues, and they also help the parties explore various options that might help settle the case.
So the mediators are lawyers. Are they able to help the pro se litigant by giving them legal advice or assistance?
No, unfortunately, the mediators have to remain totally neutral, and they cannot, under any circumstances, give advice or assistance.
So do the mediators make any decisions about the case? For example, can they force the parties to reach a settlement?
No, mediators can do neither. They can't make any decisions for the parties, and they cannot force anybody to settle the case.
What about confidentiality? Does the mediator share any information with the judge about the case?
No, what happens in mediation stays in mediation, and it remains totally confidential. The mediators don't discuss anything with the judge assigned to the case, and anything that the parties tell the mediator privately remains totally confidential unless they give the mediator permission to share certain details.
Thanks for sharing, Paul.
It's been my pleasure, Eric. Thank you.
Now that we know what role the mediator serves, let's switch our focus up to how the mediation process works. Up next is the mediation conference protocol.
These are the basics of the protocol. An order setting the mediation conference will be entered by the court. The order will include the date of the conference, name of the mediator, due date for the mediation statements and supplements. In addition, a pro se prisoner early mediation waiver form will be attached to the order. As required by the protocol, the parties will submit their mediation statements and supplements to the pro se case administrator. You must also include the signed waiver with your mediation statement and supplement. If the signed waiver is not included, your case will be removed from the program. The case will then proceed in the normal manner. It may also be necessary to sign a medical records release form if your case involves medical claims. The mediator will review the mediation statements and supplements. An informal telephone conference may be arranged by the mediator to discuss any issues concerning the mediation. At any time before or during the mediation, the mediator may request additional information and documents concerning the case. The plaintiff will appear by video conference. All defendants and/or their representatives will appear in person at the United States Courthouse. The representative has full settlement authority.
Good afternoon. My name is Ann Washington, and I will be your mediator today. Please introduce yourselves and tell me what your roles are in this case.
My name is Donald Jones. I'm the plaintiff in this case.
Thank you.
I'm Kenneth Wilson, and I'm the warden at the facility, and I have the authority to settle this matter.
Thank you.
I'm Kenneth Roger. I'm the correction officer and defendant in this case.
Okay.
I'm Regina Calhoun, Assistant Attorney General, and I represent the defendants in this case.
Okay.
I'm Betty White. I'm a nurse at the facility, and I'm the other defendant in this case.
Okay.
Mediation sessions will begin with an explanation about the process and the ground rules.
Let me lay some of the ground rules. Please be respectful. Please don't argue with each other. Talk to each other. Don't talk to me. It's not my role to actually settle this case, but to help you settle this case. Please not be confrontational. This should be a conversation, not a confrontation, okay?
At some point, the mediator may meet with all of the parties to discuss the case. At other times, the mediator will hold confidential meetings with the parties and discuss settlement offers. If the parties agree to settle, the terms of the settlement will be placed on the record by the court on the same day. The settlement will be final, and the court will enter an order dismissing the case. If the parties do not settle, it will be placed on the record and the case will proceed in the normal manner. The following is about the requirements of the mediation statement. The statement can be no longer than 5 pages. It must be sent only to the pro se case administrator and the opposing side. The exhibits are limited to 5 pages. The important factual and legal issues should be highlighted as necessary. Include a short statement explaining what the case is about. Include a short discussion of disputed factual, legal, damages, and evidentiary issues. Next, we'll highlight details of the mediation supplement. The supplement is limited to 1 to 2 pages marked for mediator's eyes only. It must be sent only to the pro se case administrator and not the opposing side. Include an honest discussion of your strongest and weakest points. Have realistic settlement options that you believe would be fair, including monetary and non-monetary solutions. Include a brief discussion of anything else that you believe is important for the mediator to know.
Before we conclude, here are some tips to consider in preparation for mediation so you can get the most out of the process. First, focus only on the claims that remain in your case. Don't talk about claims that were dismissed. This will help you, the other parties, and the mediator focus on what matters. Next, think about how to explain your claims to someone who knows nothing about your situation. You want others to understand exactly what happened and how it has affected you. Provide only the necessary details. For example, don't talk about what you had for lunch on a certain day unless your claim involves something about being denied a proper diet. Don't try to sound like a lawyer or use Latin phrases. Avoid stating legal conclusions without giving the facts describing what the defendant did. Be brief with your information when presenting those facts. Be honest with yourself and the mediator about your situation. No exaggerations or spin. During the mediation process, keep these tips in mind. Make sure to cover your most important points first. Avoid any unnecessary details. Keep your remarks short and simple. Show respect for all the participants. Even when you disagree with them, stay calm at all times. Attack the problems that led to the lawsuit, not the people involved or each other. Focus on problem solving for the future rather than dwell in the past. Your goal is to affect your future. Focus on the reasons that support your position and learn about the reasons behind the other side's differences of opinion. Set realistic goals and expectations. Prioritize your goals into 3 categories of importance: what you need, what you want, and what might help settle the case. Carefully listen and observe the other parties when they are talking. People often reveal their thoughts and feelings by the words they use. Pay attention to body language. You can't learn anything if you're always talking. Remember that the mediator doesn't take sides. Their role is to help the parties reach a deal. It is not the goal of mediation to convince the mediator that you're right and the other parties are wrong. The mediator does not decide the case. Keep an open mind to all viewpoints and possibilities. Be flexible about your position as you learn new information and consider all your options. Last but not least, the settlement. Think about what kind of settlement you want. Although most people think in terms of money damages, there are also many other forms of settlement that may be available. For example, if your complaint has to do with medical care, consider whether a visit to the doctor outside the prison would be satisfactory. Other possible options could be a special diet, increased recreation time, or an assignment to a prison job. Settlement options cannot include early parole, commutation, goods from outside vendors, or specific items from the prison store. Mediation is an opportunity for you to have your voice heard. In mediation, you can negotiate a more creative resolution. If accepted by the other side, may be far more satisfactory than any outcome in court. And now, a final word from Chief Judge Hood.
Thank you, Eric. Hello, my name is Denise Page Hood, and I am the Chief Judge of the United States District Court for the Eastern District of Michigan. With me is one of our magistrate judges. Please introduce yourself.
Thank you. I'm Patricia Morris, and I'm a magistrate judge, and I'll also be the referral judge for the purposes of this mediation program.
Thank you. I hope you found this video helpful in explaining the Prisoner Pro Se Early Mediation Program and how it can be a benefit to you. I would like to thank Judge Victoria Roberts, Magistrate Judge Patricia Morris, the Clerk's Office staff, Ken Williams, Eric Lewis, and the volunteer mediators for making this program possible.
Thank you, Judge Hood. This concludes our video. And remember, the Pro Se Prisoner Early Mediation Program gives you the opportunity to let your voice be heard.